Hi guys, this is Asal. I'm studying for the bar and I wanted to review my notes with you. So today I'm studying civil procedure and I'm studying discovery. So discovery is actually very important because there's a lot of small details into it. For example, there's a work product, there's the scope of discovery, there's the interrogatories. That's a very hard word for me to say, so you're gonna laugh at it every time I say interrogatories. So there's the interrogatories, there's the depositions, so there's actually a lot into it. But the good news is that when you see it on your exam, you're gonna know that's discovery. Like you're gonna recognize a deposition and questions, interrogatories. So that's basically all there is to it. I'm gonna start by defining the concept a little bit, and I would like to tell you where to look for the rules. So you wanna look right here, Rule 26. So actually Rule 26 all the way through Rule 37 are all the discovery rules. Like right here, it starts by duty to disclose. It's the part A is the required disclosure, and it just goes on and on about the time to disclose. The discovery scope, that's part B. That's very important. I've underlined it. So I really suggest that you open this book and you pull out Rule 26 and you go through it, Rule 26 through 37. So what is discovery exactly? I would like to tell you about the Black's Law definition of discovery. So discovery is a compulsory disclosure of a party's request of information that relates to the litigation. So all there is to it is that the party is requesting information. So they're trying to discover information. That's how this works. So what is compulsory discovery? So discovery is not optional. Under compulsory, it's not optional. For various reasons, people are often reluctant to produce relevant information. Without the mechanism to force people to produce information, even when they don't want to, parties often could not obtain the evidence they need. So this is, it's kind of compulsory. You're kind of forced to produce the information because, of course, the other party doesn't want to cooperate and doesn't want to produce the information, but they kind of have to. The next thing I would like to talk about is the basic discovery process. So there's this whole process to it. How this works is that one side serves a proper discovery request to the other side. And then the other side decides that, okay, I'm not going to respond timely. So what happens is that the other side now will move to compel. And then the court grants the motion, and then okay, if the court grants the motion, the other person has to comply. But what happens if they still don't comply? That happens. So over here, you get very nasty sanctions imposed. So the next thing I would like to talk about is what I mean by relevant means. So I mean that it must be logically connected and tending to prove or disprove a matter in issue, having the appreciable probative value, that is, rationally tending to persuade people of the probability or possibility of some alleged fact. So the discovery should be able to persuade people, it has certain information that we need. So relevant to what? So remember that the Rule 26B part has actually been amended in 2000. And then the next thing you want to think about is the sphere of relevance. So what is the sphere of relevance? What is the relevant information exactly? You want to think about that. And there's also some limits to the discovery, which is the work product doctrine. I'm going to make a whole video on that. And also the Rule 26B2C, which is unreasonably cumulative or duplicative information. So you don't want too much information. And finally, there's the balancing test that the courts look at. They look at the pros and then they look at the cons. So for example, the pros, benefits of discovery, and then the cons would be the harm to the producing party. So the courts will look at both things, the pros and the cons. And then finally, the last thing I would like to talk about is the improper discovery request. So try to resolve without involving the court. So even if the improper discovery request is improper, you kind of want to work it out with the other attorney without involving the court. Just be civilized, work it out. And then the next thing is failing this, if the parties, the attorneys, they're just not getting along, then you ask the court to resolve. So you seek for a protective order or you object to discovery, and then you want to make sure that you have good arguments. So that's very important. So right now, all I talked about was basically I introduced the rule. I told you that it's here, Rule 26. This is where you find your rules. And then I told you about the mechanism. I told you about the scope of discovery. Again, it's right here. On the part B, scope and limits, it says that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issue at stake in the action and the amount in controversy the parties. So it's like a lot. All you have to do is read it. I don't want to read the whole thing for you. So I'm just going to stop in the middle of the sentence so that you can go back and pull out the rule yourself. And finally, I talked about the limitations on the scope of discovery, such as the work product. So I wanted to make a very short video, so I'm just gonna wish you good luck and have fun studying.